Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And basically in the previous lecture, we had finished with the writs, okay? All the types of writs we had discussed, and even we had discussed the difference between the martial law versus the national emergency. Okay, we had completed it. So basically, if we talk about the rates, so we know that there are 5 rates provided in our constitution. Okay. First is habeas corpus, mandamus, prohibition, certiorari, and last one was quo warrant. Okay. So we have discussed these rates in the proper manner. All right. And basically, if we talk about this, so the next question which we are going to see is that what is the article of martial law? Okay. This is the question I'm going to ask you. What is the article of martial law? And your options are these. Article 33, Article 35, 34, and Article 36. Okay. So these are options, and basically you have 30 seconds to think and answer, and then your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So the correct answer of this is Article 34. So Article 34 of the Indian Constitution provides for the martial law, while the Article 33 provides for the fundamental rights of the armed forces. All right. So these were the things that we had discussed in the previous lecture. So basically in this lecture, we are going to start from where we had left. All right. So I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. All right. So basically now we are going to start the area of affecting certain fundamental rights. Okay. So if we talk about it, so basically there is an Article 35 of the Indian Constitution. All right. There is an Article 35 of the Indian Constitution. Okay. And that lays down the power to make the laws to give effect to the certain specified fundamental rights shall vest only in the parliament, not in the state legislatures. All right. So basically we can say whenever we talk about any law, any particular law made to affect the fundamental rights, so basically the power grants to the parliament or at the central level. All right. And this is basically done for the one main purpose, which is to ensure the uniformity. Okay. Throughout the country. All right. This provision ensures that there is a uniformity throughout the India. The same thing I have told you with regard to the nature of those fundamental rights and punishment for their infringement, or you can say for their violation. All right. In this regard, the Article 35 contains the following provisions. Let's see. First is that the Parliament shall have and the legislature of a state shall not have. Okay. It means the power is with the Parliament, not grant to the state legislature. The powers to make laws with respect to the following matters. And the first matter is prescribing residence as a condition for the certain employments or appointments in a state or a union territory or a local authority or other authority under Article 16. Like we know, Article 16 stands for the equal opportunities in public services. Okay. But the Parliament having the right to maintain a condition of residence as an exception to this equal opportunities. Thereafter, empowering the courts other than the courts and the high courts to issue the directions, orders, and writs of all kinds for the enforcement of fundamental rights prescribed in Article 32, which stands for the constitutional remedies. So, as per the Article 32, the Supreme Court could issue the directions, orders, and writs. And as per the Article 226, the power vests with the high courts. Thereafter, restricting or abrogating the application of fundamental rights to the members of armed forces, police forces, paramilitary forces, etc. All right, as per the Article 33. Because in the previous lecture also I had told you that these are the pillars of national security, so that's why there is a things. Thereafter, indemnifying any government servant or any other person for any act done during the operation of martial law in any area, Article 34. Okay. Like we had seen, the executives by their own and even the state legislatures could not declare any area and its disturbed area and could impose the martial law. This power basically vested with the parliament of this country. Okay. Thereafter, the parliament shall have and the state legislature of legislatures of a state shall not have the powers to make laws with prescribing punishment for those acts that are declared to the offences under the fundamental rights, so that the uniformity could be ensured throughout the country. And the first is untouchability, Article 17. Like we know, as per the Article 17, the untouchability must be restricted and prohibited in India. Now, if we're talking about the untouchability, here I have a question for you all. During the same thing I have told you also. During which dynasty the concept of untouchability came into existence? During which dynasty the concept of untouchability came into the existence? Okay. So now you have 30 seconds to think an answer, then I will give you the answer. Your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th, 11th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The times up. So the answer is Gupta dynasty during the ancient India. Okay, during this time, basically the concept of untouchability came into the existence. All right. Thereafter, trafficking in human beings and the forced labor, as per the Article 23. Article 23 prohibits the practices of begar, or bandhua. All right, known as the forced labor. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above acts, thus making it obligatory on the part of the Parliament to enact such acts. Which means the parliamentary power to make the laws and the responsibility is not the discretionary. So that if the Parliament wants, then only they will act. It is obligatory, so Parliament could not deny the responsibility to make the laws and legislatures upon these acts. Okay. Thereafter, the third thing which we could see here is that any law in force at the commencement of Constitution with respect to any of the matters is specified above is to continue in force until altered or repealed or amended by the Parliament. Which means that if we talk about the British India, okay, if we talk about the British India, so the one thing which we know is that British India had so many laws and legislatures. So if there is any legislature or law relating with which? Relating with the fundamental rights or protection of rights of citizens. All right. And the same law was in the force when the Constitution was commencing. So that particular law is not going to be abrogated or dismantled until or unless it is further altered, repealed, or amended by the Parliament as per the new Indian requirements. Okay. If this is not done, the law will continue as it is. It should be noted that Article 35 extends the competence of Parliament to make a law on the matters specified above, even though some of those matters may fall within the sphere of the state legislature in the state list. Okay, it means that the majority section, if we talk about it, majority section is with the Parliament, and only the minority lies with the state legislatures. Got it? Thereafter, if we talk about the present position of right to property, because we know that the right to property was a fundamental right until or unless it was created by the 44th Amendment Act of 1978. This 44th Amendment Act was the reason why now we do not have the right to property in the list of fundamental rights, because it was removed by it. So originally, the right to property was one of the 7 fundamental rights covered under the Part 3 of the Constitution. Okay, and later it was cleared by the Article 19(1)(f) and Article 31. Article 19(1)(f) guaranteed every citizen right to acquire, hold, and dispose of property, alright, which is under the category of right to freedom. Article 31, on the other hand, guaranteed to every person, where he is a citizen or the non-citizen, means the foreigners, right against deprivation of his property. Okay, it means that the first right is giving the protection or freedom to acquire and buy and dispose of the property, while the second one gives the protection that if the citizen or the non-citizen bought a property in India, so he or she could not be deprived of it. Okay, and these two provisions were removed when the 44th Amendment Act of 1978 removed the right to property. Okay, so it provided that no person shall be deprived of his property except by the authority of law. Okay, until or unless the government or the parliament passes a law so that they could acquire the property for the necessity of the condition, then the property could not be deprived. Empowered the state to acquire or requisition of the property of a person on 2 conditions. Okay, the first condition states that it should be the public purpose only. Okay, like the government wants to make some pond, wants to make some park, okay, wants to make some highway and all. Second, it should provide for payment of compensation amount to the owner. It means that if the property of someone has been acquiring by the government, the person to whom the property belongs is entitled to receive the compensation amount in lieu of giving his property. Okay, it means that the arbitrary acquisition of property is not allowed. Got it? That's the thing. Thereafter, if we talk about the another scenario, since the commencement of the Constitution, okay, the fundamental rights to property has been the most controversial. Like the Constitution was commenced in 1950 till 1978. Okay, it means almost for the 28 years, the right to property as a fundamental right has been the most controversial one. It has caused a confrontations between the Supreme Court and the Parliament. Parliament is allowed to make the rules and regulations about the fundamental rights, and Supreme Court is obligatory to save the rights of the citizen. Okay, so whenever these two properties matched with each other, the single reason was the fundamental right to property. It has led to the number of constitutional amendments, like the First Amendment, 4th Amendment, 7th Amendment, 25th Amendment, 39th Amendment, 40th Amendment, and even the 46th Amendment. Now you can see 1, 2, 3, 4, 5, 6, and 7. Total 7 amendments were there. Okay. So through these amendments, Article 31A, 31B, and 31C have been added and modified from time to time to nullify the effect of Supreme Court judgments and protect the certain law from being challenged on the grounds of contravention of fundamental rights. Because we know whenever the parliament passes any resolution in anything over the conditions of the fundamental rights, then the people having the right to move to the court if their rights are violated under the Article 32. So basically this led to the confrontation between the Supreme Court and the Parliament many a times, and for this there are amendments, 7 amendments which have made so far, okay, and added these articles which protects the certain provisions from the judicial action of Supreme Court judgments. Most of the litigation centered around the obligation of a state to pay compensation for acquisition or requisition of private property. Okay, like so many times whenever they had faced a you can say the confrontation, basically there was a matter of state obligation to pay the compensation, okay, or acquiring and requisition of the private property forcefully. All right. Thereafter, if you move forward, so therefore, there was a 44th Amendment Act of 1978. Okay. This abolished the right to property as a fundamental right by repealing the Article 91F, okay, and the Article 31 from Part 3, which are comes under the category of fundamental rights to property. Okay. Instead, the Act inserted the new Article 300A in Part this under the heading of right to property. It means that basically it was transferred from being the fundamental right to the legal right. All right. So basically, it means it provides that no person shall be deprived of his property except by the authority of law. Okay. Thus, the right to property still remains a legal right or a constitutional right, so no longer a fundamental right. It means that this implication gets some relaxation in comparison with the fundamental right. It is not a part of the basic structure of the Constitution, so that it could be amended easily. All right. Now, if we talk about this, so the right to property as a legal right, as distinct from the fundamental rights, having the following implications. Okay. And what are these implications? Let's see. First, that it can be regulated, therefore, it could be curtailed, it could be abridged, or it could be modified. Okay. Without a constitutional amendment by an ordinary law of the parliament. Like if we talk about the fundamental rights, so we know the fundamental rights are even not absolute, but they are qualified. Okay. So basically, these could be not that easily curtailed, abridged, or modified without doing the constitutional amendment. But right now, right to property is an ordinary legal right. Okay. So that's why it could be easily curtailed, abridged, or modified without making the constitutional amendments. Okay. Thereafter, protects the private property against the executive action, but not against the legislative action. Okay. It means that the executives could not acquire the property of the private nature until or unless the legislation passed the law. So that's why it is known as authority by law. Thereafter, in case of violation, the aggrieved person cannot directly move to the Supreme Court under the Article 32, which is the right of constitutional remedies, including the writs, because it is no longer a constitutional right. Okay. He can move to the High Court under Article 226. Why? Because we had seen the High Courts could issue the writs in the case of fundamental rights and in the case of ordinary legal rights. Okay. Thereafter, no guaranteed right to compensation in case of acquisition or reacquisition of the private property by the state is required. Okay. So, the fundamental right to property under the Part 3 has been abolished. The Part 3 still carries two provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Alright, it means that still this part having the sympathy for the one whose property has been acquiring by the state. These two cases where compensation has to be paid are: first case is when the state acquires the property of a minority education institutions, Article 30. Okay, and when the state acquires a land held by a person under his personal cultivation and the land is within the statutory ceiling limits, then Article 31A. So if these two are the conditions, then basically compensation will be granted to the person whose property is being acquiring by the government. The first provision was added by the 44th Amendment Act of 1978, the same act which deleted the right to property as a fundamental right, while the second provision was added by the 17th Amendment Act of 1964. Further, Article 31A, 31B, 31C have been retained as an exception to the fundamental rights. It means that the provisions of these could not be challenged under the violation of fundamental rights. So if we talk about the exceptions to the fundamental rights, first is saving of laws providing for the acquisition of estates. So we can say Article 31A saves the 5 categories of laws from being challenged and invalidated on the grounds of contravention of the fundamental rights conferred by the Article 14, like equality before law and equal protection of law. And Article 19, like the protection of 6 rights in respect of the speech, assembly, movement, etc. They are related to the agricultural land reforms, industry, commerce, and they include the following. First is acquisition of estates and the related rights by the state. These things could not be challenged in the court. Taking over the management of properties by the state, amalgamation of corporations. All right. Thereafter, extinguishment or modification of rights of directors or shareholders of corporations, and extinguishment or modification of mining leases. Okay. Then the Article 31A, it does not immunize a state law from judicial review unless it has been reversed for the President's consideration and has received his assent. This article also provides for the payment of compensation at the market value, not as per the value decided by the government. The market value, whatsoever is the market value, when the state acquires the land held by a person for his personal consideration and land is within the statutory ceiling limit. All right. Thereafter, the second case is validation of certain acts and the regulations. So Article 31B saves the acts and regulations including the 9th schedule from being challenged and invalidated on the grounds of contravention of any of the fundamental rights. So the scope of Article 31B is wider than the 31A. 31B immunizes any law which is included in the 9th schedule, but 31A could specify only the few laws. Okay. And then, however, in a significant judgment which was delivered in the case of IRQLO case 2007, the Supreme Court held that there could not be any blanket immunity from judicial review of laws including the 9th schedule. Okay. And then the court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting law under the 9th schedule so that whatever the legislation has stated, this could be covered up. It is said that the laws placed under the 9th schedule after the 24th April 1973 when the Keshavananda Bharti case was happened. Okay, like the laws which have been included in the 9th schedule after the 24th 1973, they are open to challenge in court if they violated the fundamental rights which have been guaranteed by these articles 14, 15, 19, 21 or the basic structure of the constitution. It was on 24th April 1973 the Supreme Court first propounded the doctrine of basic structure or the basic features of the constitution for the first time in the Keshavarnanda-Bharti case. Originally in 1915, 9th schedule contained only 13 acts and regulations, but at present in 2016, their number is 282. Of these, the acts and regulations of the state legislatures deal with the land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. Got it? Thereafter, the second thing is here is the saving of laws giving effect to the certain directive principles. Article 31C inserted by the 24th Amendment Act of 1917 containing following two provisions. No law that seeks to implement the socialistic directive principles specified in 39B, 21 or 22 shall be void on the grounds of contravention of the fundamental rights conferred by the Article 14, equality before law and equal protection of laws, or Article 19, like the protection of six rights in respect of the speech, assembly, movement, etc. Thus, no law containing a declaration that is for giving effect to such policy shall be cautioned in any court on the ground that it does not give effect to such a policy. In the Keshavarnanda-Bharti case 1973, the Supreme Court declared above second portion of 31C as unconstitutional and invalid on the grounds that judicial review is a basic feature of the constitution and hence cannot be taken away. Alright, so now let's take about the criticism of the fundamental rights. First, there are excessive limitations, like there are innumerable restrictions, exceptions, qualifications and explanations. Hence the critics remarks that the constitution grants the fundamental right with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as the limitations of fundamental rights or the fundamental rights and limitations thereof. Thereafter, the second is no social and economic rights because they are promised by the DPSP, which are non-enforceable in courts. List not comprehensive, many consist of the political freedom only, makes no provision for the important social and economic rights like right to social security, right to work, right to employment, rest and leisure and so on. These rights are made available to the citizens of advanced democratic countries but not in India. Also, the socialistic constitution of East by USSR or China provided for such rights. Thereafter, no clarity is there. They are stated in vague, indefinite and ambiguous manner. Various phrases and words used in the chapter like the public order, minorities, reasonable restrictions, public interest are not clearly defined, only mentioned. The language used to describe them is very complicated behind the comprehension of the common man. It is alleged that the constitution was made by the lawyers for the lawyers. Sir, Ivor Jennings scans the Constitution of India as the paradise of lawyers because the language is somewhat of judicial and complicated. Okay. So students, basically in this lecture, we have done with the fundamental rights. In the next lecture, we will start with another important topic. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.